This is precisely why foreign policy execution is not placed even in the Article 1 legislative branch, and definitely not in the slow motion, supposedly apolitical Article 3 judicial branch. It's placed in the Article 2 executive branch, where the Constitution allows for a unitary, single executive officer to make coherent and cohesive foreign relations decisions. President Donald J. Trump is racing towards yet another consecutive victory at the U.S. Supreme Court, this time on the question of whether his use of the tariff power delegated to him by Congress under the International Emergency Economic Powers Act, his use of that power in defense of our great nation, whether that use of that power is lawful or whether the United States should be left essentially defenseless against the trade abuse under which the U.S. has been suffering for the past several decades. Trump's winning strategy for winning the tariff case before SCOTUS has been ably put forth by the administration's magnificent Supreme Court warrior, General Solicitor John Sauer, and we'll be reading his brief to the Supreme Court filed just a few days ago. And in today's show, we'll be breaking that down. General Sauer's SCOTUS argument in defense of Trump's Article 2 executive branch tariff authority, all in plain English. This actually combines two separate tariff cases. You don't need to worry about that too much. Just be aware. And of course, John Sauer, Solicitor General, Department of Justice, Article 2 executive branch, joined by other very good lawyers. Brett Shumane is excellent. Sarah Harris, excellent. All of them do wonderful work. So the questions that the Supreme Court has asked to be argued, and this is something the Supreme Court does regularly, they say, we want you to focus on the particular questions here. Whether the International Emergency Economic Powers Act authorizes the tariffs imposed by the president pursuant to a variety of proclamations and executive orders. That's question number one. Two, if the IEEPA does authorize the tariffs, whether the statute is unconstitutional because it unconstitutionally delegates legislative authority to the president. There is a constitutional doctrine of law that says Congress cannot simply grant its core powers to the president. It can't say the president can pass a bill into law, for example. It can delegate subordinate powers, but not its core powers. So the second question here is essentially, has Congress delegated a core power which would be unconstitutional? And question number three, whether the unelected black-robed tyrannical inferior district trial court that stopped Trump's tariffs in one of these two cases lacked subject matter jurisdiction. That's a polite way of saying, did they do it in the absence of authority, as these unelected black-robed tyrannical inferior district trial courts so often do? Jurisdiction question. The district court, the unelected black-robed tyrannical inferior district trial court in Learning Resources, one of the two cases combined here, issued a preliminary injunction on May 29th. The government filed a notice of appeal the next day. The court's jurisdiction rests on 28 U.S.C. 292A1. The judgment in the second case, Federal Circuit in Voss Selections, was entered on August 29th. Petition of certiorari was filed with the Supreme Court, so they went right from this court to the Supreme Court on September 3rd and was granted on September 9th by the Supreme Court. Supreme Court agreed to hear both of these cases on September 9th and combined them. These consolidated cases address President Trump's lawful imposition of tariffs under the International Emergency Economic Powers Act, IEEPA, which the president, in his exercise of power over the military and foreign affairs, has determined are necessary to rectify America's country-killing trade deficits and to stem the flood of fentanyl and other legal drugs across our borders. To the president, these cases present a stark choice. With tariffs, we are a rich nation. Without tariffs, we are a poor nation. The president has stated that 1 year ago, the United States was a dead country, and now, because of the trillions of dollars being paid by countries that have so badly abused us, America is a strong, financially viable, and respected country again. Suddenly revoking the president's tariff authority under IEEPA, Trump warns, would have catastrophic consequences for our national security, foreign policy, and economy. The president has made clear that if the United States were forced to pay back the trillions of dollars committed to us, America could go from strength to failure the moment such an incorrect decision took effect. In short, President Trump and his advisors have determined that erroneously invalidating the IEEPA tariffs would have catastrophic consequences for our national security, foreign policy, and economy. The president observes that these deals for trillions of dollars have been reached, and other countries have committed to pay massive sums of money, which he projects could reach $15 trillion. The president has emphasized if the United States were forced to unwind these historic agreements, the economic consequences would be ruinous instead of unprecedented success. Now, if all of this sounds like political policy, and therefore within the realm of the two political branches of government, Article 1 legislative branch and Article 2 executive branch, and outside the reach of the supposedly apolitical branch of government, the Article 3 judiciary, you would be correct. The courts should have nothing to say about any of this. If there's any dispute here, it's a political policy dispute to be settled between Congress, which holds the core tariff power, and the president, who's exercising the power delegated to him by Congress. If Congress objects, Congress is free to change the law and strip the president of his authority under the IEEPA. They can simply repeal the IEEPA, and then Trump would have nothing to say. John Sauer continues. President Trump's IEEPA tariffs are plainly lawful. Congress has long granted the president broad authority to employ tariffs to address emergencies. IEEPA continues that tradition by expressly authorizing the president to regulate importation of foreign goods to address declared national emergencies. Since the early days of the Republic, regulating trade has always encompassed the imposition of tariffs, and IEEPA's broader statutory scheme confirms that regulating importation includes the use of tariffs. Now, I expect a big part of the attack on Trump here is going to be based on this requirement of AEP, an exigency, a condition, just like we saw with the National Guard cases, right? Under 12406, Trump can federalize and deploy the National Guard if there's a foreign invasion, if there's a rebellion or danger of rebellion, if the law cannot be carried out with the regular forces. Those are conditions that trigger the 12406 authority to federalize and deploy the National Guard. And what the courts have been arguing is over who gets to make the call that the condition has been met. The inferior, unelected, black-robed trial court judges have been saying they get to make the call. The unelected judges get to second-guess the commander-in-chief as to whether the emergency has been met or exists, whether the exigency, the condition has been met. And of course, the Ninth Circuit Court of Appeals so far has been finding that no, the president gets to make the call. To the extent that courts have anything to say about it, if there's any evidence to support the president's call, we have to defer to the president's judgment. I expect the argument here is going to be the same. IEEPA requires an emergency. Who gets to make the call on whether or not this condition of an emergency has been met? Trump's opponents are asking the unelected black-robed tyrannical inferior district trial courts to make that call. I would suggest that the Constitution mandates that the Article 2 executive branch president makes that call. John Sauer continues, presidents have relied on IEEPA to address a wide array of emergencies, and IEEPA embodies an eyes-open congressional grant of broad emergency authority in this foreign affairs realm. President Trump our elected, democratically elected Article 2 executive branch president determined that tariffs are best suited to address the trade deficit and drug trafficking emergencies, and those determinations warrant deference from the courts. IEEPA provides that Congress and the political process, see it here? The political process, not the judiciary, serve as the principal monitor and check on the president's exercise of IEEP authority. And this, I believe, will be the winning principle with the Supreme Court. In spite of the lawfulness, this is where victory will come from. In spite of the lawfulness of the IEEPA tariffs and the president's determination of their country-saving impact, the unelected, black-robed, tyrannical, inferior district trial courts wrongly invalidated the tariffs. These erroneous decisions jeopardized the president's efforts to deal with major national emergencies without any sound legal basis. In fact, the lower courts could not agree on why exactly IEEPA does not authorize these tariffs. The district court in one case, Learning Resources, incorrectly concluded that IEEPA does not authorize any tariffs at all, largely because IEEPA does not expressly use the word tariffs. That rationale imposes an unjustifiable magic words requirement contrary to this Supreme Court's case law. The Court of International Trade instead held that because another statute addresses balance of payment deficits, IEEPA cannot cover the same ground. But the statutes are overlapping and mutually reinforcing. IEEPA addresses emergencies, whether or not they involve trade deficits, and Section 122 addresses trade deficits, whether or not they involve emergencies. By contrast, the en banc Federal Circuit, in a 7-4 decision, incorrectly held that IEEPA might authorize some tariffs, just not these tariffs, or any other tariffs that the court considers too enduring, too significant, or too widespread. So this is the unelected, black-robed, tyrannical, inferior federal court saying, well, the president doesn't have this authority to make this determination, but we do. We unelected judges get to make the call. John Sauer continues, but neither IEEPA nor the Major Questions Doctrine allows courts to fabricate such atextual, know it when you see it, limitations on the president's emergency powers. In fact, such limitations are in direct violation of the separation of powers. Here, where the president's foreign policy authority includes all that he possesses in his own right as the democratically elected Article 2 executive branch president, plus all that the Article 1 Congress can delegate, and his actions are supported by the strongest of presumptions and the widest latitude of judicial interpretation. If affirmed, the lower court is affirmed decision against Trump. If that decision is affirmed, the erroneous lower court decisions would cause significant and irreparable harm to the foreign policy, trade policy, and national security of the United States. The Secretary of State, the great and powerful Marco Rubio, explains that suspending the effectiveness of the tariffs would lead to dangerous diplomatic embarrassment, which emboldens allies and adversaries alike and would likewise interrupt ongoing negotiations midstream. This is precisely why foreign policy execution is not placed even in the Article 1 legislative branch, and definitely not in the slow motion, supposedly apolitical Article 3 judicial branch. It's placed in the Article 2 executive branch, where the Constitution allows for a unitary, single executive officer to make coherent and cohesive foreign relations decisions. As Marco Rubio underscores, the erroneous decisions by the inferior courts exposed the United States to the risk of retaliation by other countries based on a perception that the U.S. lacks the capacity to respond rapidly to retaliation. The courts would have to approve anything the president did. Upholding the invalidation, the Secretary of Commerce notes, would have devastating and dire consequences. It would resign the U.S. to permanent dependencies on foreign supply chains and accelerate the drift toward America's decline into a vassal state to global manufacturing powers that include our geopolitical allies. Curtailing presidential authority now, the Secretary of Commerce warns, would be catastrophic. Of course, this doesn't mean, folks, that the president's authority here is absolute and not subject to check. It just means that it's subject to check by Congress, the second political branch of government, Article 1, not by the Article 3 judicial branch. Keep in mind, the Chief Justice of the United States, John Roberts, is the guy who decided to find Obamacare to be constitutional on the grounds that it's a tax, even though the Obama administration had argued at every opportunity that Obamacare was not a tax. Because if it qualified as a tax, it would have had to be introduced in the House of Representatives, and it was not. It was introduced in the Senate. So it couldn't be a tax, or it wouldn't be legitimate. Despite that, John Roberts decided it's constitutional because it's a tax, because he wanted to defer to the collective judgment of the political branches and not have the apolitical Article 3 judiciary override the political process. Where do you think that guy is going to come down here? Summary of argument. By authorizing the president to regulate importation, IEEPA plainly authorizes the president to impose tariffs, which are a traditional and commonplace way to regulate imports. This Supreme Court has long recognized that regulating trade includes imposing taxes or tariffs. President Nixon imposed tariffs that were upheld under identical language in IEEPA's predecessor statute, which the Supreme Court has recognized authorized essentially the same actions as IEEPA. That IEEPA does not use the word tariff is immaterial. This Supreme Court has repeatedly rejected such magic words requirements. Indeed, the Supreme Court has held that a statute authorizing the president to adjust imports includes tariffs, making this an even easier case. Plaintiffs argue that even if IEEPA authorizes tariffs, it does not authorize unlimited tariffs. But neither plaintiffs nor the Federal Circuit, which endorsed this position, identify what limited tariffs are acceptable or how to tell the difference. They also overlook the limits that Congress fashioned in IEEPA itself, including the time limit on emergencies, the enumerated list of exceptions, and congressional oversight. The Federal Circuit relied on the major questions doctrine in interpreting IEEPA to allow some tariffs, but not these tariffs. But that doctrine is an aid to interpret ambiguous statutory terms, not a license to impose atextual limits not found in a statute, based on a judge's policy views of which tariffs go too far. The Supreme Court also has never applied the doctrine in the foreign affairs context, where Congress presumptively does grant the president broad powers to supplement his own Article 2 authority. The major questions doctrine has particularly little force when, as here, the statutory delegation is to the president directly, concerns emergencies, and copies language from a predecessor statute that was held to authorize the action challenged here. No alternative rationales justify invalidating these tariffs. The Court of International Trade deemed the trade tariffs invalid because they did not satisfy the requirements for tariffs under Section 122 of the Trade Act of 1974, which imposes 15% and 150-day limit on non-emergency tariffs. But IEEPA and Section 122 are complementary statutes with different requirements and limitations, and each should be given full effect in its own domain. The Court of International Trade deemed the trafficking tariffs invalid because collecting duties on lawful goods does not directly deal with drug traffickers. But the tariffs deal with the declared national emergencies because that phrase is broad enough to encompass actions that serve as leverage. And the president's determination that the goods trade deficit and contraband trafficking are emergencies resulting from unusual or extraordinary threats are essentially judicially unreviewable. IEEPA instead imposes comprehensive procedures to ensure that Congress, the other political branch, Article 1, periodically reviews the basis for those emergencies and whether to terminate them. The check on the president's purported abuse of the delegated tariff authority is Article 1 Congress, not the Article 3 judiciary. Plaintiffs alternatively contend that if IEEPA authorizes tariffs, that authority would violate the non-delegation doctrine, which prohibits Congress from delegating legislative authority outside the legislative branch. That doctrine has little or no force in foreign affairs context, where the president enjoys inherent Article 2 authority, and Congress must of necessity paint with a broader brush. Delegating supplemental powers to the primary actor in the foreign affairs arena does not trigger any of the concerns underlying the non-delegation doctrine in the domestic context. This Supreme Court, has repeatedly rejected constitutional challenges to broad congressional delegations to the president to regulate international trade, including through tariffs. And even if the domestic version of the non-delegation doctrine applied, IEEPA would still satisfy it. IEEPA prescribes both a general policy to deal with certain foreign threats that constitute an emergency and sufficiently clear boundaries for the president to exercise those powers, including default time limits, enumerated exceptions, and detailed congressional reporting requirements. The Learning Resources District Court case lacked jurisdiction. The Court of International Trade has exclusive jurisdiction over any civil action against the government that arises out of any law providing for tariffs. Presidential modifications to the harmonized tariff schedule qualify as such laws, and plaintiffs' claims arising out of these modifications, they seek to declare the modifications unlawful, enjoin their enforcement, and set them aside, so it belongs in the Court of International Trade, not in federal district court. The judgment of the unelected Black Robe Tyrannical District Court in case 24-1287 should be vacated and the case remanded with instructions to dismiss for lack of jurisdiction, and the judgment of the Court of Appeals in 25-250, the other tariffs case, should be reversed. Respectfully submitted, John Sauer, Solicitor General, Brett Shumate, Sarah Harris, both excellent lawyers. These other lawyers I'm less familiar with. All right. Well, that is what I expect will be the winning strategy before the Supreme Court, which will affirm President Trump's authority to apply the tariffs as he has done to bring in trillions of dollars into American coffers under the IEEPA. That case, oral argument happens December 8th, which is just about a week and a half from now. So not this Wednesday. I believe it's a Wednesday, but the following Wednesday. Wait a minute. Hold on a second. Let me check the date there. November 5th. November 5th. So not this Wednesday, but the next Wednesday. The Supreme Court will hear oral arguments, and if that happens, they'll probably be streamed, and I'll cover those arguments in real time. That will be awesome. I think we'll hear the same kind of pro-Trump kind of arguments we've heard in recent oral arguments before the Supreme Court, including hearing Justice Ketanji, I'm not a biologist, how would I know what a woman is, Jackson, make her very compelling legal argument of just trust me, bro. Just trust me, bro.